Welcome to this latest edition in our video interview series here at iConnect. My name is Richard Albert, and today our subject of discussion is developments in French constitutional law. And my guest is François-Xavier Millet, a professor of public law at the University of the French West Indies, and also a research associate at Toulouse University. François, welcome.
Thank you, Richard. Thank you for interviewing me.
It's a pleasure to have you. So, François, my plan for today is to ask you questions that will cover 4 or 5 different themes. The first theme will be the separation of powers in France. The second is constitutional review. The third is France and its territories. The fourth is the interrelationship between the French Constitution and Europe. And the fifth will be Charlie Hebdo. So we have a lot of ground to cover, and I thank you again in advance for your time. This is really going to be fascinating. So the first question, François, just to help us understand the French Constitution, how are the powers divided under the French Constitution?
So what one has to understand is that you have to go back on the origins, on the genesis of the French Constitution back in 1958, when actually there was a war in Algeria and there was a so-called Fourth Republic at that time, where you had actually a lot of ministerial instability, and there was a so-called régime des partis, so political parties that were really like having power, and the parliament was always overthrowing the government, basically. So a lot of instability that was not good for the at the time of war in Algeria, where you actually needed new institutions. And de Gaulle came back to power, and there was a new constitution, the current constitution, the 1958 constitution, where actually, compared to the Fourth Republic, there was a need for a so-called parlementarisme rationalisé, namely a streamlined parliamentarism, aiming at giving more powers to the executive and curbing the powers of the parliament, actually. So the balance of powers, it's not really balanced in a way, because the balance rather tilts toward the executive. And not only the executive through certain procedures giving more weight to the executive compared to the parliament, but to the president of the republic, who is, as de Gaulle put it himself, the keystone, the cornerstone, the clé de voûte of the French institutions, having a lot of powers himself, and a lot of powers being supposedly justified by the very high democratic legitimacy enjoyed by the president of the republic, thanks to his or her election with universal suffrage from 1962.
And so, François, today, is the President of the Republic still supreme in the separation of powers in France?
So the thing is that there has been several critiques that have been aired over time about the powers of the president, that was possibly too powerful, actually. Among the different institutions in France, and even François Mitterrand, the former president, when he was an opponent to General de Gaulle in 1965, wrote a book called The Coup d'État Permanent, so the permanent coup, that was especially used by de Gaulle as the president of the time, showing that the president here was perhaps too powerful. So what happened now is that in 2008, there was a major revision of the Constitution, of the French Constitution, took place, that actually limited the powers of the President of the Republic. How did it limit it? Well, for instance, it limited the exceptional powers that it enjoys, the famous Article 16, that gives full powers to the President in cases of emergency. Then the president could take any measures that were appropriate for the good functioning of the institutions. But then, for instance, the Constitutional Power in 2008 amended the Constitution in order to give more power of consultation to the Parliament, for instance. And the Conseil Constitutionnel also, which was already forecast before, had some powers to review the acts and this kind of things. So we have like fewer powers also. The president was actually what made a major difference is that its power of appointing top civil servants is now limited, because before it was not subject to any control, but now it goes through consultation of the parliament and of the standing committees in the parliament that I can actually oppose a nomination decided by the president of the republic. And the thing also which is absolutely crucial to mention is that in 2000 there was a reform that actually the term of mandate of office of the president was put down from 7 years to 5 years, and actually in line with the parliamentary majority. So this was meant supposedly to give even more powers to the president, because then there would be no problem of having diverging majorities between the parliament and the president, the so-called situations of cohabitation, as we call them in France. And at the end, so there was a risk of giving more powers to the president. Then again, the 2008 revision of the constitution allowed for the fact that the mandate, the number of mandates of the president of terms is limited to 2 consecutive mandates. So then it's a way also to avoid that the president will be elected for too long, and with the risks that it can actually entail.
And what about the role of the parliament, Francois? Has that evolved over the past, let's say, decade, 15 years?
Well, it has evolved. I would say that there are two different lines. Some measures concerning the members of parliament themselves have been taken. For instance, this year, a rather controversial law was passed on a law which prevented MPs from holding both a term of an office of member of parliament and of a local executive. And there was this idea of not having too many offices, political offices, of holding too many political offices, and a way like to push the members of parliament to focus only on their parliamentary work. So that's a way to enhance the credibility of and the work, the quality of the work of MPs, I believe, although some people oppose this view. And then there was also there are also measures concerning the proper working of the parliament and the powers of the parliament, actually. And for instance, in the 2008 revision, so as said, this major revision that took place in France in 2008, the new parliaments were granted, new powers were granted to the parliament, namely, for instance, setting the agenda. It's not only up to the government to set the agenda, but the agenda is being shared, the setting of the agenda. Then you have also the need for parliament's clearance to prolong military interventions abroad when it exceeds 6 months, a 6 month period of time. And you have also an interesting move, which is that the texts being discussed in plenary sessions, in public plenary sessions, are no longer the government bills, but the texts already that have been amended in commission in the standing committees of the parliament. It's this text already amended that is then being discussed by the members of the parliament. And another way to improve the work of the parliament and the standing of the parliament, I would say, is the thing that the 2008 revision also put limits to the use of the famous provision of the Constitution, namely Article 49.3, le 49.3, as we say, because this article, I'm reading it, the Prime Minister may make the passing of a bill an issue of a vote of confidence before the National Assembly. So it's really when the government cannot it's on a controversial bill, it cannot have a majority, and then he says, okay, I will push so much as I can, and if you don't agree with this text, then you have to vote, you members of parliament, a motion of confidence, basically. So it's really what epitomized this so-called parlementarisme rationalisé that was an object of many criticisms in France, and the 2008 revision limited it by limiting it to only the finance bills and the social security financing bill, and also allowed it to use this procedure only for one bill per session, an ordinary bill, not connected with finances. And then, last point on this, this provision, this controversial provision, was used some months ago by the current socialist government in France, whereas it was not even used for many years before. And it was very controversial because it was felt as an act, especially coming from a left-wing government, a strange act of the executive pushing forward a text, because it did not really have a clear majority on this.
And so let's move on now to constitutional review. I do want to come back to Parliament in a moment, but let's move on to constitutional review. So there is an institution in France, le Conseil constitutionnel. Would you say that we should understand this as an equivalent to a constitutional court? What are the traditional powers of the Conseil?
So the thing is that, as the name suggests, Conseil constitutionnel, at the beginning we did not really, I mean, the drafters of the French Constitution did not really want to make of the Conseil constitutionnel a full-fledged constitutional court, as we know in as we know in many countries in Europe, actually. Because what was the main target, the main aim, the main function of the Conseil constitutionnel back in 1958 was a way to ensure that the parliament would not overlap on the powers of the executive. So it was itself another illustration of the parlementarisme rationalisé in the French Constitution. And basically, the powers were extremely limited, and the plaintiffs that could take a case before the Conseil constitutionnel were only the official authorities, namely President of the Republic, President of both houses, basically, and Prime Minister. And then the thing it has evolved. It has evolved a lot, and now, to answer better your question, I think that we are heading towards a full-fledged constitutional court, although still things are missing. Why am I still saying that? Because there were major turning points, 3 turning points in chronological order. First one, 1971, where actually the Conseil constitutionnel itself considered that he would examine the constitutionality of bills with regard to the preamble of the Constitution. Why is it significant? Because the preamble of the Constitution enshrines, it somehow refers to the text that are the Bill of Rights, the Declaration of the Human Rights and of the Citizen of 1788, the preamble of the 1946 Constitution that contains major social rights, actually. And that was a major step taken by the Conseil constitutionnel itself about a salient decision about freedom of association. Second major step, 1974, where actually 60 members of either the National Assembly, the lower house, or the Senate in France, 60 members of either house could actually bring proceedings before the Conseil constitutionnel. What was the significance of that? Of course, it was like a way to allow the opposition, the parliamentary opposition, to take a case before the Conseil constitutionnel for constitutional review. Last turning point, 2008. Again, this major revision in 2000 that took place in 2008 that actually created the so-called question prioritaire de constitutionnalité, the priority preliminary reference on constitutionality. That is a mechanism, if I may explain a bit further what it is, about its kind of genesis and its significance. It's a mechanism that was introduced in 2008 by the revision that started being working in 2010, so 5 years ago. And it's an interesting mechanism because it is a way for any citizen considering that his or her constitutional rights, the rights enshrined in the Constitution, were breached by a statute. Actually, during proceedings before a court of law, this person can raise this question, this problem of constitutionality. Then the judge, the ordinary judge, the local judge, will examine whether the claim is serious enough. If the local judge considers that the claim is serious enough, it will send the case to either the Conseil d'État, the top administrative judge, or the Cour de Cassation, the top judicial judge, because in France we have two judicial orders, the administrative and the judicial ones. And depending on who is competent, either the Conseil d'État or the Cour de Cassation will ultimately decide whether the claim is serious enough as to the incompatibility of the law with the Constitution. It will send the case eventually to the Conseil constitutionnel, will examine the case, and if it considers that it's unconstitutional, then it will just repeal it as of its decision, the date of its decision, or as of a subsequent date. And the thing which is interesting is that why is it so major? Because it's, first of all, a way of allowing citizens of access to the justice, to constitutional justice. And it's not only up to public authorities. It's also the citizens can actually have their rights vindicated indirectly before the Conseil constitutionnel, where they consider that the law is unconstitutional and should therefore not apply to their particular case. But what is also very interesting is that Why did it take so much time compared to other constitutional democracies in Europe especially, and even compared to America? Why did it take so much time? It is actually that the law, the statute, is supreme in France. There is this idea that the law, the statute should be immune from challenge. And as they are immune from challenge, when once they are enforced, they should not be scrapped, they should not be struck down, basically. And what had happened in the past years, especially since the 1990s, is that you had ordinary judges, judicial judges, administrative judges, that were anyway like setting aside some statutes when they breached international treaties and especially European treaties. The law was therefore, the statutes was therefore no longer supreme as Rousseau wanted it to be supreme as the expression of the general will. And so instead of just relying on ordinary judges on the basis of international treaties, there were several people that said, well, why don't we introduce that in the Constitution? The idea was already aired by Robert Badinter and Georges Vedel in the early 1990s, but then it did not go until a revision of the Constitution, and the revision of the Constitution actually allowed this question prioritaire de constitutionnalité, QPC, in 2008. And actually it has been a major success because within 5 years, there have been more than 450 decisions that have been taken by the Conseil Constitutionnel. So it's really working. And it's really working, especially in matters where international treaties are perhaps not that enforced or where the rights are not that strong, namely in environmental matters, criminal matters, and tax matters. That are the 3 fields where actually the Conseil Constitutionnel has issued major decisions.
Is it fair to describe this 1971 moment, François, as France's Marberry moment?
Well, I think that it can be compared to Marbury versus Madison, indeed, because it's a way like of the Conseil Constitutionnel not to do what it was supposed to do, what it was expected to do, and when you have the expression of judges taking power for the sake of the rule of law.
I think that's fascinating. So you suggest that perhaps there's, more than perhaps, there appears to be a movement toward the Conseil becoming a full-fledged constitutional court. As we move toward that eventuality, it sounds like that, what do you think are some more needed reforms, some more needed changes to happen in order to transform the Conseil into a real constitutional court like we see across Europe?
Well, in my view, and I think that many French constitutional scholars would concur with this view. Well, first of all, we would perhaps need to change the name to bring it in line with what it is becoming, actually, because Conseil doesn't have an advisory capacity, so it should be actually called Cour constitutionnelle, constitutional court. But the main reform that should also happen, except of changing its name, is actually the makeup of the Conseil constitutionnel. Because it's always very criticized that, first of all, you have life members. I mean, the former presidents of the Republic are life members sitting on the Conseil constitutionnel. Actually, they do no longer sit. I mean, Giscard d'Estaing and Chirac do no longer take part to sessions of the Conseil constitutionnel, but the possibility, it is still allowed in the Constitution. And Sarkozy comes, well, rarely, but from time to time. I mean, he has also come. So that's something which probably should no longer be part of the Constitution. And also, perhaps we should insert a provision like to make sure that all members of the Conseil constitutionnel are people that have legal expertise. Although there was a sociologist, Dominic Schnapper, that actually was also good to have someone who is into sociology. So should we really have specific provisions about the type of persons we actually need in the Conseil constitutionnel? Well, it's debatable, but then, well, then we have to use comparative law also to understand exactly what is needed.
François, let me move on now to France and its territories. The conventional wisdom, of course, holds that France is the the paradigmatic model of a unitary centralized state. Is this conventional wisdom still true today?
Well, it's much less true because, like, as we saw in many other countries, especially European countries, I'm thinking of the UK, the conventional wisdom has always said that the UK was also a good illustration of the unitary state. And from the late 1990s, we know that there is a process of devolution that has happened in the UK. And in France, it's pretty much the same, and it even started before, in 1982 already, just 1 year after the election of François Mitterrand. Actually, we started the so-called Acte I, first act of the decentralization, of the devolution, if you want, like giving much more powers to the local communities, because before you had like the prefect, the representative of the state, that had very strong powers at the local level. And the powers of the prefect were largely scrapped. Actually, he could just act a posteriori, and he could not just remove some acts taken by the local provinces, the département in France. And there was another major revision of the constitution that happened. It's not the 2008 revision this time; it's the 2003 revision that actually inserted in the first article, of the French Constitution, that yes, the French Constitution is an indivisible republic, but its organization is decentralized. And actually it gave much more power, much more autonomy, especially financial autonomy to the local level. So there is a move, and also now there is what some say, but I'm not sure that is the third act of decentralization. So first act 1982, second act 2003, 2004. With the institutional acts taken, and currently active third act, because the thing is that we had 22 regions before, and now there will be fewer regions, like 12 big regions, and the idea would be to give more powers to the regions, because now in a globalized world, the region seems to be adequate level to implement public policies.
And so is there any chance, François, that France will one day become a federal state?
Well, that is unlikely. I mean, one never knows, of course, but because of the very republican and centralized tradition of France, that is, of course, unlikely. Although I would just qualify what I've just said with the status of overseas territories in France. I mean, I'm currently in Guadeloupe. And there is a good example with the overseas territories that, in respect with these territories, there is some kind of federal type of relation between Paris and those territories, because then you have New Caledonia that is almost independent, that is not independent. We do not know. There will be a referendum soon. Perhaps we do not. There are some problems around it. But New Caledonia is almost independent, has very strong powers that make France resemble in its relation to New Caledonia, a federal state. You have another category of overseas territory, the so-called collectivité d'outre-mer, where actually the laws and statutes of the republic apply when only with the statuses explicitly say that they apply, otherwise they have their own laws and regulations. And you have like Guadeloupe, the département d'outre-mer, departments, overseas departments and regions, like Martinique, Guyane, Réunion, Mayotte as well, where actually there have been interesting things going on, because normally the laws of the republic apply by default in these territories. But the 2003 revision introduced some margin of maneuver, some possibilities of further adaptation to the laws of the republic in these very specific territories, and it can even go that those territories can determine the rules applying to them, unless it touches the core issues of sovereignty, I would say, and of civil liberties, of course. But it's going pretty far, and for these territories there is some kind of federal model, but only for these territories.
I mentioned that I would want to come back to Parliament, and I want to do that now, but I also want to come back to the court. And I want to do so in the context of asking you about the interrelationship between the French Constitution and European Union law. Now, of course, the consequence of membership in the European Union is that it will necessarily visit some strain on the domestic constitutional order. what has been the role of the Conseil constitutionnel in managing this relationship between, on the one hand, the supremacy of the French Constitution in France and the state's membership in the European Union? And also, what has been Parliament's role in this? Well, how has Parliament reacted when there have been moments of conflict or tension between national law and EU law?
Well, the thing is that, first of all, this topic is very much my main research topic. I should already say as a start, because I did my PhD actually on the relationship between the European Union and the so-called constitutional identity of the member states, and so not only France, but mainly France, obviously. And so the Conseil constitutionnel has played a major role actually in accommodating the claims deriving from the primacy of EU law that is existential to the fact of having a common law to all member states, and on the other hand, the supremacy of the constitution, because we shall not forget that the Conseil constitutionnel is meant to safeguard the constitution. It's its main role. And the fact, how did it accommodate the claim deriving from the primacy of EU law, especially in cases where you can imagine that there will be contradictions between EU law and national constitutional law? Well, here I would like to perhaps briefly talk about two major decisions of the Conseil constitutionnel. The first one in 2006. It has already started in 2004, but the main one mentioning constitutional identity was taken in July 2006 about copyright law. And the thing is there, the Conseil constitutionnel considered that, well, I will just make it brief because it's a very long and technical story, but the crux of the matter, the main idea, is that actually there is no longer any constitutional review of EU acts, or at least of national acts implementing EU acts, unless they breach the rights and principles deriving from the constitutional identity of France. So then there will be the Conseil constitutionnel that actually can strike down a national act, national law, implementing an EU directive, for instance, when it breaches the constitutional identity of France. Of course, it does not define what is constitutional identity, and it's very debatable what it is, and it can be very, very broad. But we can think that the Conseil constitutionnel will be very reasonable in saying that, I guess, that the constitutional identity of France is about the main republican values that have been long-lasting values in France, and they date back to the French Revolution in 1789. But still, what is interesting, and it distinguishes the French case from the German case, that also the German Bundesverfassungsgericht coined this notion of constitutional identity. The major difference is that the constituent power in France can actually consent to alienating the constitutional identity in France. It's not something which is part of the eternity clause. There is nothing like eternity clause in France, where you have some provisions of the constitution, such as those relating to constitutional identity, that could not be amended. It can be amended in France. And the second decision is a decision that was issued in 2013, in April 2013, if I'm not wrong, where you had the first decision when the Conseil constitutionnel actually decided to refer a case to the Court of Justice of the European Union, to send a preliminary reference. And many saw it as an act of subservience on the part of the Conseil constitutionnel toward the European Court of Justice in Luxembourg. In my view, it is not, for some reasons. First of all, it is not an act of subservience because it is about a very specific case concerning the European arrest warrant. And the European arrest warrant, while being an EU act, but it's also enshrined in the French Constitution. So it's part of the French Constitution, but at the same time, it's an EU act. And then it's only for this that the Conseil constitutionnel felt the need to ask for interpretive guidance on the part of the European Court of Justice. And it's not an act of subservience because at the end, who has the last word? I don't like this idea because I think that in the relationship between national law and European law, we should talk more about like pluralism, about dialogue. But in any case, who could have the last word is the national judge, is the Conseil constitutionnel himself. So it's just a way like of abiding by the rules of the game and talking to one another. I think it's very important.
You mentioned, Francois, unamendable provisions, but there is one, is there not, in the French Constitution, Article 89?
Exactly, there is Article 89 about the republican form of the government that is meant to be untouchable. So you're right that there is, but I mean, compared to the German one, even that, I mean, for the Conseil constitutionnel said that there is the constitutional power can actually, that there is virtually no limit to the revision of the constitution. The Conseil constitutionnel actually made it clear again in 2003.
You mentioned in your answer to my question a moment ago your doctoral thesis, and I do my research, François, because I've discovered that you won a number of prizes for your doctoral thesis, a prize awarded by the Conseil itself. And also, I think you won, is this not correct, a university-wide prize for the best dissertation in comparative law at the European University Institute. So congratulations on your prize.
Thank you, Richard, for this. Yeah, thank you. Yeah.
Let me move on now, François, to the last category of questions that I want to ask you. Mm-hmm. Charlie Hebdo. Did the attacks on Charlie Hebdo, did that trigger in France discussions about adopting something close to, something approximating, something like the Patriot Act that we have here in the United States?
So the attacks on Charlie Hebdo were an appalling event in France that actually triggered a lot of emotion throughout the country, with a lot of people taking to the streets to demonstrate like for liberty, freedom of expression, and that we shall stay strong and united in front of terrorism. And of course, then it entered the political and legal debate. What shall we do now about terrorism? And some politicians have actually suggested that there should be some kind of a Patriot Act à la française. The thing is that so it's mainly right-wing politicians that suggested that. What happened at the end is that there was only a 10 a law on intelligence that was passed. That was adopted, and that the bill on intelligence is actually under discussion with the Conseil constitutionnel under examination. So I'm just putting the battery, because otherwise we might have a problem. Yeah. So it's under examination by the Conseil constitutionnel, and actually it goes. We do not know actually what will happen. Probably it will issue its decision next week or the week after, and because again it's a problem of how to reconcile public security and fundamental freedoms, and especially right to private life. Because in this bill on intelligence there is a lot of things about like giving administrative authorization on like wiretapping, almost like eavesdropping, even in your car at your own placing mic, and then collection of data, and how long do you keep this data, and to what extent can you use it? What is the extent of judicial review on this very administrative procedures? So yeah, let's wait and see a bit how it all evolves.
Well, François-Xavier Millet, we've been discussing about so much about French constitutional law. You've taught us a bit about the separation of powers in France, about constitutional review in France, about the relationship between France and its territories, the relationship between France and the European Union, and we've now just talked about Charlie Hebdo, and so we've covered a lot of ground, and I want to thank you for your time today. But before we go, François, could you tell us a bit about what you're working on? What are some of the research projects that you're currently undertaking and that you plan to complete in short order?
So, of course, I'm still very much interested in the relationship between legal orders, both on a practical side and on a theoretical side, and legal pluralism, constitutional pluralism. So I'm still very, very active. I try to still to keep very active in this field, but also I try to work on the overseas law, because it's a new topic since I took up my position in Guadeloupe some months ago. So overseas law, and I'm now also working on partly freedom of religion and the rule of people in constitutional adjudication. We do not stress enough the rule of people. We think that in constitutional law, it just, when at the point of adopting a constitution, and then it's much more remote, let's say. But what I've found interesting is some countries, especially in Latin America, that have this actio popularis, but some countries in Europe as well, like Hungarian discrimination cases, that have this actio popularis. So I'm currently working further on this.
Sounds like a very full research agenda. Well, François-Xavier Millet, Professor of Public Law at the University of the French West Indies and a Research Associate at Toulouse Law School. Thank you so much for joining us today on iConnect for our latest video interview. This has been very, very fascinating, and I thank you so much for your time.
It was my pleasure, Richard, and thanks to you above all.
Okay, bye-bye.
Bye-bye.